In many countries, clients often ask important questions. Who inherits if there's no will? And what must a will include to be valid? As lawyers, you need to explain these concepts in clear, simple English to people who may not speak your local language or understand your legal system. In today's class, you'll learn the essential vocabulary for wills and estates and practice beginner grammar structures like using apostrophe s and of to explain ownership, and there is and there are to describe assets and heirs. By the end of this lesson, you'll be able to give a straightforward explanation of wills, intestacy, and probate to English speaking clients anywhere in the world with accuracy, professionalism, and confidence. First, we'll learn essential words for wills and probate, simple definitions with clear examples. Second, we'll use possessive forms to say who owns what: the client's house, the house of the client. Third, we will practice there is and there are to list what exists in the estate. There is a will, there are three heirs. By the end, you'll be able to explain the basics of a will and a probate process in simple professional English. Imagine this: a client, Mr. Collins, lives part of the year abroad in another country. He owns an apartment and a small business. He says, I don't have a will. Who inherits if I die here? You answer, if there is no will, the law of intestacy applies. Usually the estate passes to legitimate heirs, such as a spouse and children. The order can vary by country. He asks, what documents do I need? You reply, there is a will option with formalities, and there are probate steps later. Let's list your assets and family members first. In this lesson, you'll learn the key words in grammar to have this type of conversation confidently wherever you practice law. A will is a legal document that explains who will receive a person's property after they die. It must follow legal formalities to be valid. For example, imagine a client named Mr. Smith. He owns an apartment in Costa Rica and wants to leave it to his spouse. He prepares a will that clearly states the apartment shall go to my wife, Anna. When you explain this in English to a foreign client, you can say, there is a will that leaves the apartment to the spouse. This makes it clear that the will controls what happens to the apartment after the client's death. An estate is everything a person owns at the time of death: their money, real estate, vehicles, accounts, and even rights. For example, imagine Miss Johnson dies owning a house in Mexico City, a car, and a savings account. All of these things together form her estate. When you explain this to an English-speaking client, you might say, the estate includes the house, the bank account, and the car. This shows clearly that the estate is not just one item, but everything the person leaves behind. An heir. An heir is someone who has the legal right to receive part of the estate. If there is a valid will, the heirs are the people named in that will. But if a person dies intestate, meaning without a valid will, then the law decides who the heirs are. For example, imagine Mr. Williams dies without making a will. By law, his spouse and children are the first heirs. If he has no children, then the parents or other relatives may inherit. When explaining this to a client, you can say, if someone dies intestate, the heirs are defined by law. This makes it clear that the law, not the person, decides who receives the estate. An executor. is the person responsible for managing the estate after someone dies. For example, imagine a will that says, I name my brother John as executor. This means John must file the probate, prepare an inventory of assets, pay debts, and then distribute the estate to the heirs. When you explain this in English, you might say, the will names an executor who files the probate. This shows clearly that the executor has a legal duty to carry out the instructions in the will. Probate is the legal process that happens after someone dies. It confirms that the will is valid, or if there is no will, it applies intestacy law. The probate also identifies the heirs, values the estate, pays debts, and distributes the property. Imagine a client asks, how will my family get the house after I die? You explain, there is a probate proceeding to recognize the heirs and transfer the house. This helps clients understand that probate is the official process that makes inheritance legal. Community property is the property acquired during marriage that belongs to both spouses equally. For example, imagine John bought a house during their marriage. When John dies, his wife Mary automatically keeps her half of the house. Only John's half goes into the estate to be inherited. When you explain this to a client, you can say, there is community property. The spouse keeps their half. This makes it clear that the surviving spouse already owns part of the property, and only the other half is part of the inheritance. Let's imagine a real situation. Your client, Miss Smith, is from the United States, but owns a house in a country in Latin America. She says, I already made a will, but how will my children actually get the house after I die? You explain, the will is important, but it's not enough by itself. First, there is a legal process to confirm the will and to distribute the property to your heirs. This process makes everything official in the eyes of the court. The correct word for this process is probate. So you can say there is a probate proceeding to recognize your heirs and transfer the house. Probate is the step that connects the will to the actual transfer of property. Now, picture another client. Mr. Gomez comes to you and says, my uncle just died. He never wrote a will. Who receives his property now? You explain, when a person dies without a valid will, we use the law of intestacy. The law decides who inherits, usually the spouse and children first, then other relatives like parents or siblings. So, the correct word for dying without a will is intestate. So you can say, if someone dies intestate, the heirs are defined by law. This word is very useful in practice because many foreign clients may have not written wills in the country where they reside, and you need to explain clearly what happens if they die without one. Now, let's try another. Imagine a foreign client, Mr. Johnson, is married to a Costa Rican woman. He says, we bought a house together. If I die, will she inherit everything or just part of it? You explain, in Costa Rica and in many countries around the world, there is a system called community property. This means that anything acquired during marriage already belongs equally to both spouses. You die, your wife keeps her half automatically. Only your half goes into the estate to be inherited by heirs. So, I said it in the answer. The correct answer is, of course, community property. So you could say, there's community property, so the spouse keeps their half and only the other half becomes part of the estate. Lawyers often need to explain who owns what in clear English. One simple way to do this is by using apostrophe S. For example, the client's will. This means the will belongs to the client. The spouse's share. This means the part of the estate that belongs to the spouse. The children's inheritance. This means the inheritance that goes to the children. Now imagine a conversation. A foreign client asks, whose name is on this will? You can answer, this is the client's will, or a client says, how much does the wife receive? You explain, this is the spouse's share. Notice how natural this sounds in everyday conversation? One important detail, with plural nouns ending in S, you only add an apostrophe. For example, the heirs, shares. And with irregular plurals, you add apostrophe S. For example, the children's inheritance. So think of apostrophe S as your shortcut to explain ownership quickly in spoken English. There's another way to show possession in English, using the word of. This form is more common in written or formal English, such as contracts or court documents. For example, the will of the client. This is the same as the client's will, but it sounds more formal. The rights of the spouse. This means the spouse's legal rights. The estate of Mr. Rivera. This phrase might appear in a legal petition or a probate file. So imagine you're reading a court document aloud for your client. You might see, the estate of Mr. Rivera shall be distributed according to law. When speaking, you could simplify this for the client and say, this is Mr. Rivera's estate. So while apostrophe S is faster and more natural in conversation, of is very common in legal documents. As a lawyer, you should recognize both and choose the one that fits the situation. Now, let's compare apostrophe S and of side by side. When you are speaking with the client, it's natural to say the client's will. But when you read or draft a legal document, you may see the will of the client. When a client asks, what part does the wife receive? In conversation, you might answer, this is the spouse's half. But in a court filing, you may read, half of the spouse is recognized as community property. So you could also explain the heirs' shares are equal. That's simple for speaking. And in writing, you may see the shares of the heirs shall be distributed equally. Both forms are correct. Your job is to choose the one that sounds clear and professional for the context. For speaking with foreign clients, use apostrophe S. For reading or explaining documents, be ready for of. In inheritance law, we often need to list what exists in the estate. The easiest way to do this is with there is and there are. Use there is when talking about one thing. For example, there is a will. Use there are when talking about more than one thing, two or more. For example, there are 3 heirs. Now, imagine this story. A foreign client asks, what documents do we need? You look at the file and say, there is a will. There is also a marriage certificate. Later, when you review the heirs, you explain, there are 2 children and 1 spouse. These are the heirs. Using there is and there are keeps your explanation simple, clear, and professional. It helps clients quickly understand what exists in the estate without complex grammar. Let's make this more practical. Imagine you're preparing the inventory of the estate. You might explain to the heirs there is 1 apartment in the estate. There are 2 bank accounts. There are several debts to pay before distribution. This language is extremely helpful when you are explaining the contents of the estate to a foreign client. Instead of complicated lists, you can simply say there is or there are, and then name the item. This way, your explanation is easy to follow, even for beginners in English. To die intestate means to die without a valid will. In that situation, the law decides who inherits, not the deceased. For example, imagine a client says, "My father never wrote a will. What happens now?" You can explain, "Your father died intestate." This means the law decides who the heirs are. Usually the spouse and children come first, then parents or other relatives. By using this phrase, die intestate, you explain clearly that inheritance follows the law, not the personal wishes of the deceased. A valid will is one that follows legal requirements, what lawyers call formalities. In most countries, this means proper signatures, witnesses, a date, and sometimes a notary public. If a will doesn't meet these formalities, it can be declared invalid. For example, imagine a client brings you a handwritten will from her uncle. It is signed, but there were no witnesses. She asks, "Is this valid?" You explain, "No. This document does not meet the formalities. A valid will requires witnesses and sometimes a notary, depending on the type of will. Without those steps, the court may not recognize it. So when you say there is a valid will with proper witnesses, you mean the will has legal force and can be used in probate. The executor. The executor is the person legally responsible for carrying out the instructions of the will. For example, imagine a client shows you her father's will. It says, "I name my brother Carlos as executor." What does that mean? You explain, Carlos, as executor, must file the probate, prepare an inventory of all assets, pay debts, and then distribute the property to the heirs. He is like the manager of the estate, making sure everything is done legally and fairly. So when you say the executor files probate and protects assets, you are describing the main responsibilities of this role. A probate proceeding is the official legal process that starts after someone dies. Its purpose is to confirm whether there is a valid will or to apply intestacy law, if there is none. The probate proceeding also identifies the heirs, lists and values the estate, pays debts, and distributes the assets. An example, a client could ask, "How will my children get my property here after I die?" You explain there will be a probate proceeding. If your will is valid, the court or notary will follow it. If you die intestate, the law will decide the heirs. Either way, the probate proceeding is required to transfer ownership legally. So when you say there is a probate proceeding before a court or a notary, you are describing the official step that makes inheritance legal and enforceable. Let's put everything together with a final story. Mr. Alvarez, a retired businessman, passes away. His will names his daughter Elena as the executor. There is a will. Elena brings it to court. She files the probate so the process can begin. There is an estate. Elena lists the assets: one family home, 2 bank accounts, and a small business. She prepares the inventory and secures everything so nothing is lost. There are heirs. The spouse and 2 children are recognized. Because of community property, the spouse keeps her half first. Only Mr. Alvarez's half enters the estate for distribution. There are debts. Elena pays them from the estate's accounts before distribution. And finally, there is distribution. Elena uses the will to divide the remaining assets fairly, then submits a final accounting. Throughout the process, Elena performs all the executor duties: opening probate, protecting assets, keeping records, paying debts, and distributing the estate. If you were explaining this to a foreign client, You could say in clear English, the executor opens probate, makes a list of assets, pays the debts, and then distributes the estate to the heirs. There is a will. There are heirs. There are assets to manage. This story combines the vocabulary, the grammar, and the legal phrases learned in class. It shows how you can give a step-by-step explanation of inheritance in simple and professional English. Let's review everything you learned in today's class, step by step. First, you built vocabulary for inheritance law. You now know how to use words like will, estate, heir, executor, and probate. You can also explain community property, which is very important in many countries. These words are the foundation for talking about wills and estates with English-speaking clients. Second, you practice grammar, ownership, and list. You learn how to show relationship with apostrophe S and of, the client's will, the will of the client, the children's inheritance, the inheritance of the children. You also use there is and there are to list documents and assets in the estate. There is a will. There are 3 heirs. These simple patterns make your explanations clear and easy to follow. Third, you learned important legal phrases. Die intestate, to die without a valid will, leaving inheritance to be decided by law. Valid will, a will that follows legal formalities like signatures and witnesses. Executor duties, the specific tasks the executor must do, such as opening probate, making an inventory, paying debts, and distributing the estate. Probate proceeding, the legal process to confirm the will or apply intestacy. Finally, you applied all this in a wrap-up story about Mr. Alvarez's estate. You practice explaining in plain English. There is a will. There are heirs. The spouse keeps her half. The executor opens probate, protects assets, pays debts, and distributes the estate. This lesson showed you how to explain the entire inheritance process from the will to probate using beginner-level English structures. Explaining wills and estates in English can be difficult, but you don't have to learn alone. In our legal English community, you'll get full access to the beginner, intermediate, and advanced courses, plus live sessions and a private forum to practice with other lawyers and students across the region. If you want to keep building your legal English step by step, click the link in the description and join us today.